Hey, everyone. I'm trying to change my view. How are we doing on people? Are we all, enough of us are here?
I don't know for sure.
Okay. Stand by. There's like a feedback, some kind of noise. Is that just someone's phone connection? Better.
Cindy, I think we have a quorum if Chair Trom, if you want to get started.
Good. So can we call the meeting to order? We're going to do a roll call. I think we're ready to go.
Sure. First of all, let me remind everybody this is being recorded. And please note, if you're not speaking, to mute yourself. Okay. Professor Antrom.
Here.
Chris June Kiliani.
Here.
Bevan Lister.
I'm here.
Laura Fitzsimmons.
I'm here.
Rob Tellis. Julie Kavanaugh-Bill. Joni Eastley.
Yep.
Lorinda Whitman.
I am here.
Dave Mendiola. Jeff Wells.
Here.
Drew Christensen.
Here.
Kate Thomas. And Justice William Moppin. And it does appear we have a quorum.
Great, thank you very much. So we'll start as usual with public comment, and those for anyone who's here, and those can also be emailed. And Cynthia, I just wanted to ask you, we do not have any emailed comments, is that correct?
That's correct.
Okay, is there anyone who's on the line who would like to make a comment? Okay, hearing none. Let's move to the approval of the minutes from our meeting on February 24th. Do we have any corrections?
Madam Chair, I thought they looked good, and I'll make a motion to approve.
I'll second.
Excellent. All in favor of the motion? Aye.
Aye.
Aye, and I'm sorry, I didn't identify myself. It's Joni Eastley.
Thank you, Joni Eastley. And we know it's going to be either your corrections on the minutes or your motion to approve them on the minutes. So we recognize your voice. Thank you very much. Okay, so that's good. I think we have a short meeting today, so we'll hear our update from the department, and then which shouldn't take too long. So Marcy and Jared, do you want to give us the update?
Yes, good afternoon, everybody. Just to start off, I wanted to let everyone know that we have a new hire, Thomas Qualls, and he is our new deputy director. So I'm very excited to get him out to the county so we can introduce him to everyone. So he's on the meeting today.
Hello, everyone.
Welcome aboard.
Thank you.
Going to the next item of annual reporting, we just wanted to update the board that annual reports are due from each of the counties on May 1st. So we've been actively reaching out to all of the counties to inform them of this. And it's been a lot easier this year than it was last year because people actually know who we are. So we'll be following up to make sure that everyone is submitting their reporting in the upcoming days. We've also been actively working on the plans for the provision of indigent defense services. We've made it our goal to try and go out to each of the counties to appear on the Board of Commissioners meetings. And we've actually started working on some of these counties. Our belief is as these plans become available, we're hoping to add them to the agenda for the board to review and approve if appropriate. And then we're hoping to put them on our website so that some of the counties that don't necessarily have a county manager or someone in charge of this certain area can copy these plans or use them as a reference when they're creating theirs. So that is our goal with that. And Chair, would you like us to move on to the update on the budget?
Sorry. Yeah, I think that that's fine.
And I did provide as an attachment to the meeting, the budget closing documents. Our budget tentatively closed. I mean, obviously it's subject to change before the end of the legislature, but there were several decision items that the committee was to determine. The first was whether to appropriate $75,000 for the Davis monitor, and that was approved in our budget. The second was to appropriate $25,000 for training and resources for indigent defense attorneys. So we're very excited. We hope to be able to do a training in person for the next 2 years with that funding. And the final add that was approved is to place $1.2 million in each year of the 2021 through 2023 biennium to fund the 10 Davis counties, the 10 Davis rural counties in the stipulated consent judgment, and to place this funding in the interim finance committee contingency account, whereupon the department can request the funding based upon the actual needs. So that was approved to be able to provide funding to those rural counties. And
Really? It was approved?
Yes.
Wow. I'm shocked. Thank you.
Yes, to the 10 rural counties, not the 15 rural counties. And we do have a meeting with the Governor's Finance Office Director, Susan Brown, on May 20th to receive more clarification on what the funding can be used for and obtain more guidance on that. So we'll be able to let the board know when we get more information.
And Chairman Trump, can I say something?
Yeah, of course. Go ahead, Laura.
That was an incredible amount of work and devotion that you put into that, all of you at DIDS. You started out with nothing and look where you got. And I know we're all just so impressed. So thank you.
I'll dogpile on that comment.
I'm sure it was Ann's letter that did the trick.
It was so it was just such a strange experience because I listened to Marcy testify and I felt like I was in a black box. Like I called in but couldn't see, and it was just like such a different kind of government. But you know, it worked, and I think that just the coordinated strategy and your testimony was excellent. So I'm glad that they got the message. I was wondering if you could just kind of spell out a little bit like what you think that might look like in terms of a process and then sort of just how it might play out over the year.
Yes, I would love to do that. And before I do that, I mean, I think obviously it was this great board and a great governor that helped us get this funding. So it wasn't necessarily our department. We had a lot of help to be able to get there. As for how we think that this will play out, we are actively in the process, like I said, of reaching out to the counties and building their plans with them. And part of our duty is to help them estimate the cost of the plans. And one thing that we're trying to encourage some of the counties that use the contract method is to add in an appointed council court administrator. And this is something that the counties don't necessarily have. And we'll be reaching out to Drew as well as Krista Meyer in Washoe County to try and determine what would be needed for that, estimate a cost of how much that would be. But we believe that this could provide a lot of solutions for the counties, and this difference that the state is covering could possibly be used to cover that. This position could possibly provide coverage of who's going to be the person that goes and drops off those applications for attorneys in the jail. who's the person that shows up at the initial appearances and who ultimately assigns each case and determines the budget. So as we build the county's plans, we'll create an estimate as to how much we think that it's going to cost. And then on a quarterly basis, the counties will be submitting their fiscal reporting. And once they receive their maximum amount, then we'll do a request to the interim finance committee to request reimbursement on their behalf. But some really great things are happening with these counties. Nye County, for example, is planning on putting funding in an independent budget for experts and investigators. So they're hoping to be able to do that. Some of the counties are kicking around the idea of this appointed court administrator, but they're concerned about the cost. So we're hoping that we'll be able to give them some answers that this might be a possibility for them in the future.
Well done.
Yes, I agree. And so part of that is just that it's going to be like a slow rollout as information comes in and the department is going to the internet, to the IFC to get the money. So it's going to take a while. I mean, I guess I'm hoping that at least what will come of that process is sort of hard requests and experience and data, right? So that will then filter into a budget request that might actually get granted at the front end, which would be best and a lot easier to administrate. But I mean, it's fantastic. And I mean, we're not going to violate Davis, but it's also just great to see some of the evolution that's happening as the counties are sort of rising to the occasion and being role models for each other. So that's just shaping up nicely. So thank you for that. All right. Any other comments on that? I think, is it, what's next for you? Is it the bill draft update then?
Just the last thing for me is the bill draft request update. I was concerned whether or not our request had died in the legislature, but I believe that we are exempt from any of these deadlines. I reached out to LCB and was informed that they expect our bill draft. And if you recall, this is a bill draft where we're trying to get rid of caps for certain cases. We're trying to create separation between the appointment and the selection of counsel. And we're trying to change how funding is provided to indigent defense attorneys. Rather than going through the judge, they can go through us or their court administrator, their appointed counsel administrator, or whoever's appropriate. We expect that to come out, according to LCB, sometime prior to May 1st. So once we receive that, we'll forward it on to the rest of the board. And the rest of this update will be covered by Jared.
And Marcy, they're putting them out. I've gotten 2 new bills just today in the last few minutes that came out of LCB that were just like yours. They were exempt and just now came out.
Jared, before you talk, I just wanted to note that Rob Tellis is here and Kate Thomas is here, and I'm sure that Cynthia noticed, but I just wanted to say it. So thank you for joining us. All right, go ahead, Jared.
Thank you. Good afternoon. Jared Hickman, for the record. I'm updating on our application process, including some issues that have arisen and been dealt with along the way. And then we'll get into the exciting part, which is the training. So starting with the applications, a reminder, the application to verify or determine eligibility arises from statute 180-430 sub 1B. It is the department's duty to determine whether attorneys meet requirements established by the board and maintain a list of those attorneys. Once the regulations were effective on March 5th, we took several steps to provide notice of the application process, and that began on March 9th. We utilized the Nevada Lawyers email blast. We sent out notice through the AOC to rural judges. Through Drew and Krista Meyer in Washoe County, the appointed counsel administrators, we sent notice to their groups of attorneys. We utilized bar associations and provided notice to bar associations. Of course, our website, we provided individual county contact to management or board of commissioners. And then in the May issue of the Nevada Lawyer, we'll have a notice about the application process as well. So we've taken a pretty wide approach to providing notice of that process. And, you know, again, it's in preparation for county plans. As they're developing plans, we can provide information as to lawyers who have applied and what they are eligible to take in terms of cases under our experience requirements. And the counties can use those to incorporate in their plans for, either contract lawyers or individually appointed case type lawyers. Our process is simple. It's an online application through our website. We've looked at that at prior meetings, so I'm not going to spend any time there. In total at this point, we've had 55 applicants. There are 5 applications currently pending. At this point, only one's been rejected outright, and that was an application for a municipal court defense contract. So that fell outside of our scope, and that was through a phone call with the lawyer, explaining to him that was outside our scope, was dealt with that way. Of the 55 applicants, 33 are what I'm calling multi-jurisdictional applicants. That's applicants that are looking for work in 2 or more counties. The remainder of those are single jurisdiction applicants. I am prepared to provide a breakdown per county of lawyers that have applied, but for purposes of this, it may serve best to kind of highlight the issues. Some of the issues we're seeing are current contract attorneys at this point have not applied. That holds true in Carson City, Douglas County, Lyon County, and Mineral County. We are planning individual outreach to those attorneys to follow up on the application, see what their plans are and if there's anything that we can assist with through that process. The other issue in some areas are the lack of local attorney application, and that kind of works in concert with the contract public defenders. In Douglas County, for instance, there's only one of the local attorneys that applied. In Lyon County, for instance, only one local firm applied that consists of 2 attorneys. Mineral, which is historically the issue, there are no local attorneys there. There are no local attorneys that have applied. That service is generally provided from an attorney coming in from another county. Those are essentially the coverage issues that we are looking at. In terms of dealing with that, as I mentioned, I think we're going to approach that through individual follow-up with the attorneys. Before moving on to the next section, are there any questions or additional information regarding the application process and results thus far?
I think you can go on. I'm not seeing anyone.
No, thank you.
Thanks.
Okay. So hearing none, we'll take a look at the item that's kind of a subcategory of this item is the conditional approval. Just kind of as a starting point for informative purposes, the fact pattern is generally 2 or more attorneys in a firm. One of the attorneys meets or exceeds the experience requirements. The second or other attorneys does not meet the experience requirements for certain case categories, due to being relatively new to the practice. And so the question becomes, how do we handle that when they are associated together in a firm where there is an attorney similar to a public defender's office that can provide mentorship, supervision, guidance for a category of cases that they may not be eligible for on their own. Where we started at in looking at this issue was with the Clark County, Washoe County plans and appointed counsel administrators, specifically the provisions entitled mentoring training programs. And just as a brief aside, I'll read into this, generally what those paragraphs entail, and then get into how we've continued and then bring up our ultimate question. But those paragraphs in the Clark and Washoe plans include language that is virtually identical, and it is that the Office of Appointed Counsel will pair all qualified mentors with a mentee to allow the mentee to enhance their professional development and improve their level of qualification as counsel via experience. On a case-by-case basis, the Office of Appointed Counsel will mentor will navigate which cases the mentee will be assigned and what particular duties the mentee will be assigned. Neither mentor nor mentees will receive additional compensation for participating in the program. In no instance shall an attorney who has not tried at least one felony trial be permitted to try a felony case without an experienced criminal defense attorney mentor sitting a second chair. And then again, the Washoe plan has virtually identical language. The tact that we have taken with that is, rather than an outright denial or an outright approval, we've fashioned what we're calling a conditional approval. And in the highest case category, the non-capital category A's and the quote unquote high B's, we are requiring that the younger attorney be supervised in accordance with Nevada Rule of Professional Conduct 5.1, and that if there is a critical appearance, that attorney, the younger attorney that is, cannot appear by themselves. They must appear with the supervising or mentoring attorney. In lower case categories, for instance, the gross misdemeanor through category B, on the one occasion where we've had to fashion a conditional approval for that, the conditional approval is under supervision and guidance and mentorship in accordance with Rule 5.1, and encouragement that that attorney would not be at a critical or significant hearing by themselves, but only appear with the mentor or mentee, mentor or supervising attorney. The question becomes is really how we handle this moving forward. There are two options that we see, and one is to leave it as is. The power to determine the eligibility also includes the ability to set conditions, and that's out of a principle of administrative law. Or the second option is, when it comes time to form permanent regulations, we make conditional approval or a mentor program explicit in the regulation. Other issues that we see with this issue is dealing with the language that neither mentor nor mentees will receive additional compensation if we are applying that outside of firm context. For instance, if a single attorney who has a contract is not qualified to handle a certain case category, how do we use a conditional approval in that circumstance without providing compensation to the supervisor or mentor attorney if they're able to find one? The question that, from our perspective, we're looking at it is that an economic disincentive? And do we need to, as we're developing plans with counties, look and see if that is a possibility to be addressed within that plan? So with that, questions, comments, thoughts?
Jared, this is Jeff. I know in Clark, even though we have a large volume, the number of trials is still small. It's probably less than half of 1% of all cases actually go to trial here. Despite that, because the number is so much, it gives attorneys an opportunity to get a trial in. How does that work in some of the rural counties? I'm wondering if even for some of the smaller counties, even the one trial rule, it might take them years to get to a place where there's one trial. Because they might be getting decent offers on the cases, and best interest of the client at the time is to take those offers and such. But I don't know how to compare in some of those counties.
So I guess the answer to that is, at this point, we probably don't have the hard data to give you a factually accurate number. I think I could say anecdotally that same observation in Clark County applies across the board. There may be a little bit more trials in some counties. For instance, I know over through this COVID shutdown, Lyon County, for instance, has still been having jury trials and having jury trials frequently. I know in Carson there was one scheduled to go, but recently was vacated for extraneous reasons. But I think anecdotally it's probably the same.
I have a question, and I guess part of it goes to, if you kind of related to Jeff's. So in terms of fulfilling the requirements, or if you're granted conditional approval for a year, have you anticipated some way of kind of cataloging what you've done over the year, which may or may not be a trial, but it might be other work in terms of trying to figure out whether at the 1-year anniversary you're now likely to be approved, or whether your conditional approval would keep going in the same status for a while longer?
How we have fashioned that at this point is in the responding letter to the application. It details the terms of the condition, and then a sentence including that once the experience requirements are met, to provide notice to the department. Again, the individual experience requirements include a waiver provision for substantially similar experience or other skills that may be viewed and weighed upon, as meeting the requirement. So essentially how we're doing that is not necessarily a new application, but just provide us notice of what you think meets the requirement. Let's take a look at it and see if we can make a determination from there.
Mm-hmm. I think that's good. And I guess I would just add that I think Jeff's point about lack of trials is really important because, well, first of all, you wouldn't want someone to go to trial just to be for their own reasons, which might be a bad idea. So, I mean, sort of valuing other things like contested motions might also be really useful. And I guess depending on sort of who's in that category of, sort of junior attorney in, kind of waiting to be a full-fledged attorney, that, I mean, sort of depending on what you're seeing, there could be training kind of targeting those people as part of, sort of how you train, how you plan that, I guess, might be useful.
Thank you.
That sounds good. And I just wanted to flag the point that you made about the sort of regulations is just, this goes to something I think we'll probably be needing to think about late summer is that late summer that we're going to be doing permanent regulations? We have to do permanent regulations. So one question to flag is just whether we should tuck something in that makes explicit this conditional approval process, even if it's, just saying about that much, right? Which is you could also get conditional approval subject to conditions set by the department, so that that's explicit and no one's surprised. And that might be something that we kind of tuck into the permanent regulations. So
in terms of time frame, I believe the temporary regulations will expire in November. So we're looking at starting that process enough in advance to make sure we have times for the workshop, adjustment, and public hearing. And then on top of that, as we kind of go through and deal with particular issues in the counties, we also maintaining a list of things that may be workshop discussion points in terms of tweaking the regulations. So this is certainly one of them, and probably a more pressing one considering we're doing the applications now. But there are a few others as well.
Right. All right, that's great. Any other comments on the?
Chairman Tom, this is Drew.
Oh yes, go ahead, Drew.
Just wanted to comment, Jared, Marcy, and I have kind of been going roundabout with this conditional approval. Luckily in Clark, we don't face that because of the volume of lawyers that we have. But the point of the conditional approval was just that dynamic that in some counties, the only people who are applying really don't meet some of the requirements to handle those significant Category A felonies. And it's difficult to approve them, that even though statistically, even the Category A probably won't go to trial, it still could. And you'd hate to see the young lawyer be in a position to have the case set for trial and not necessarily have the wherewithal or the expertise to know some of the logistics and strategies that should be in play. One thing that we've done here is when Jared read some of that mentor-mentee language, the rule kind of is no compensation, but we've realized that you have to kind of make exceptions to that, just because you don't want, some young lawyer, even on a smaller Category B, C kind of case, having their first trial by themselves. So we have instituted a policy, and maybe this can be a consideration for the discussion Marcy will have with the finance people, to use some of this money in the event that an attorney faces that situation where they're about to go to trial, or that the trial is likely, to compensate the mentor attorney or the more senior attorney to sit second chair, whether that's for the entirety of the trial, some pre-trial prep work, and there's a variety of things we've done down here to kind of compensate for that specific scenario. So I want to applaud Marcy and Jared, because it is a fine tightrope when you're looking at counties that don't have a lot of applicants, but at the same time, the applicants they have aren't maybe necessarily qualified to take any case that comes to the door, right? So just want to throw that out there.
I appreciate that comment. And I guess it will be, I think it sounds just right to think about this, sort of have enough wiggle room to be able to sort of fit the situation and the person as well as the case. And also to be listening to what these attorneys are saying as they sort of are getting through that first year. And I'm sure I hope that they'll be in touch and you'll be in touch with them to sort of make sure that they're kind of that they're on the right track for approval and getting the right amount of supervision and whatever it takes to get that supervision to happen. Because I can imagine if we're starved for attorneys, we may be starved for mentors willing to do the work. So, yeah. All right, that is great progress though. And yeah, I'm just impressed that you're getting through all of this and doing it so thoughtfully. So that's really useful. Should we move on to the training update? Go ahead.
Thank you. So the training, we just concluded our April 2-day CLE conference, and from our perspective, I think it was a success. We had more attendees than we originally anticipated. Just to give a breakdown, I know we've covered this at prior meetings, but in quick summary, over a day and a half, we provided 10 CLE credits. There were 3 presentations. The first presentation on April 22nd was Maria Pence and John Arascata. Maria being an attorney from Douglas County, John Arascata, the Washoe County Public Defender. They did a presentation on kind of the life cycle or building your case on the way to trial. It was called the Anatomy of a Case. The second presentation was done by Julia Murray, the training director in the Clark County Public Defender's Office, and Mario Walther, an attorney in Lyon County. It was focused on competency proceedings in the procedure, ins and outs of those proceedings, and then with a focus on challenging the proceedings if necessary. We had 123 registered people for that class, for those presentations, and actually 106 in attendance. On the 23rd, we had an all-day CLE with Larry Posner in his chapter method of cross-examination. 141 people registered with 112 in attendance. And trying to get some useful data or useful information for the board to see in terms of how it went. We did, through the webinar program, have a survey, a post-conference survey available, and I am going to share that screen right now. So this is the survey in line with the CLE board recommended survey for accredited providers. You can see on the 22nd, the 2 presentations there, the overall quality of the program rated the highest, and generally across the board, that's what we're talking about. The written materials were 38% excellent, with 42% saying meeting expectations. The only real, I don't even know if I'd consider it negative feedback when asking about the webinar platform. There were a few people, a small percentage, that did not love it, but overall, most people were satisfied with that. And then on the 23rd, scrolling down, again, overall, the feedback from that presentation was in the excellent or the highest category. Looking at the numbers across the board, with the exception of the webinar platform, the running away with it, everyone was pleased with the quality of the presentation. It went very well, and we are looking forward to doing that again, hopefully in person next year. And then in terms of training for the upcoming months, in May, we have a 2-hour substance abuse CLE with the Dr. Joanna O'Flaherty, attorney wellness and peer support. in June, appellate procedure. July and August will be a two-part CLE on writs. The July CLE will be focused on pretrial writs. The August CLE will focus on post-conviction writs. In September, Professor Trom graciously agreed to reschedule her CLE until September, and that'll be a focus on search and seizure issues. I think we previously discussed a focus on dog sniff issues. And then in October and December, pardon me, I'm looking at the list on the board behind the computer. In October and November, we've got a two-part series on DNA basics with Chris McGee from the University of Colorado Boulder. And then we're looking at an ethics CLE in December. So overall, the conference I think went off very, very well, and we're very pleased. I think my favorite, well, the one that meant the most to me, anyways, in terms of feedback, was an email that we got unsolicited outside of the survey process that in part read, "That was amazing. That was an amazing conference last week. By the way, everyone in the office really got a lot out of it. It was the most applicable and useful CLE I've been to in years. Congratulations on a very impressive first annual conference."
That's exciting. That just really is wonderful. I wanted to just say that Jared and Marcy and Patrick, while he was here, and probably Thomas stepping in the door, worked with a lot of people to pull that together with help from the Washoe County PDs who were involved, and then also from the Clark County PDs who were involved. And there was just this really nice synergy of the urban experts kind of teaming up with rural county attorneys who are also expert, but doing it together. And that was just a really nice model, which I'm sure will be repeated. So there was just a lot of thought that went into it. And obviously it's a huge success, and the webinar platform reviews will be better when we meet in person, I guess. But congratulations. It's just really great. And I think, I don't know if you wanted to say anything, Marcy, but I think that the lawyers just really appreciate the community forming and bonding that's happening, the solidarity that's happening by being connected through these trainings and meetings and the other, sort of consultation opportunities that DIDS has created. So DIDS is just doing a lot in different ways of sort of running a department and doing lobbying kind of legislation work, and then getting this stuff off the ground at the same time. It's just a really great accomplishment. So.
And Chair, I was hoping to add just a little bit, it was nice to see attorneys from across the state all in the same web chat room where we could actually start to get to know each other. And hopefully next year when we do it in person, we can meet each other in person. But I also wanted to let the board know that in addition to all of the indigent defense attorneys in the rurals, we purchased the NACDL 2019 and 2020 sample motions, which was a CD-ROM that we sent to every contract or public defender in the rural counties. So that was sent with a letter introducing ourselves again, letting them know of our SOAR program, which is the outreach program, putting them in touch with students, helping them investigate certain cases that they have, and then also our First Fridays and telling them of our CLE calendar. And we also are exploring the possibility of purchasing Larry Posner's book for each office and each county's indigent defense providers throughout the state, including Clark County and Washoe County. We're hoping to buy that book and provide it to everyone because we got such positive feedback across the state.
That's awesome. Any other comments? Questions?
Sure, this is Drew again. I'll just piggyback off the comments. I was able to attend the webinar Thursday. I couldn't make the Friday session, but I thought it was fantastic. And I would echo the comments that as long as I practiced here, it's still kind of silos around the state. We're individual units where we kind of know our own defense bar and the practices within our local community. But just hearing, the presentations from Washoe and from some of the other jurisdictions, I think that's the best part about this is bringing the state together where we're starting to interact, not just within counties, but now statewide. And so practices that are happening in Washoe that we quite frankly may not have known about that could benefit us here in Washoe or in Clark and vice versa. And then that extends to the rurals. And so I really enjoyed it. So I think when we do meet in person, we'll just make those better connections and have a comfort level reaching out, not necessarily just locally, now statewide, to get some help and expertise, whatever particular issue the lawyer may be facing in their particular case.
Mhm.
So kudos.
Agreed. Any other comments?
Just the last thing that I'd like to say is, again, to extend a very, very hearty thank you to everyone that participated in that. John, Maria, Julia, Mario, and then the rest of kind of the planning or steering committee for the training. It was all very, very useful information, and I think culminated in a really good event. So, from us, thank you. And I don't know that we can say it enough.
Well, thank you. No, it was a really nice team effort, and with so much going on, all the more impressive. So that's great. Should we talk about scheduling issues? Okay. So there's a few things that are coming up. One is the May. Did you want to add or sort of talk about the May meeting? Locations for future meetings, because the state is opening back up, and then possibly an in-person meeting. I'm seeing, Dave, are you wanting to talk? Marcy, can I hand it over to you to sort of talk about these things?
So, Dag Long, could you pop in if I say anything incorrectly? But Dag Long has provided us with Directive 44, which shows that the suspensions of certain aspects of the open meeting law are going to be terminated on June 1st. So that means that starting June, we will be having in-person meetings again. And my understanding is that Zoom and telephonic appearance will still be allowed by members, but we'll have to have a physical location of where we're going to have the meeting. As for where we're going to have the meeting, we've reached out to try to schedule that, but each organization is creating their own opening plan, so we have not been able to schedule it, but we will keep the board up to date as to what we're doing. We are requesting that if you're planning to travel to Carson or Vegas, like we've had the physical locations before, if you're planning on requesting reimbursement for travel, if you could reach out to Cindy beforehand, because we do have limited travel budgets and we're bumping up against the end of the fiscal year. So if you just reach out to Cindy Atanasio and let us know how much you think the travel will cost, hopefully we can make sure that we have sufficient funding to cover who's going to be requesting travel. And then finally, our request we'd have two requests. First is to vacate the May 26th meeting or to possibly move it. On May 26th, there is a swearing in for all new bar members in Las Vegas. We are hoping to go down there to spread information about our department to those individuals that are newly sworn in, to make sure that they know that they can apply to be on our list if they're interested in providing indigent defense services in the rural counties. So we'd like to put together a pamphlet and try and do more outreach by appearing in person at that event if possible. But that is currently scheduled at the same time as our May board meeting. So what we'd request is that we remove the May 26th board meeting. We continue with the board meeting, which I believe is currently set for June. Did I give you the date, Professor Traum?
I think it's June 23rd.
Yes, I'm just opening my calendar, but I think that's right.
Okay. June 23rd, which would then be in person in Carson and Las Vegas. And then I'd also like to possibly start the discussion of having a board meeting where the entire board is in one location. There's been requests for that for us all to get together. And what we are proposing is our September 29th board meeting. As the plans are due September 3rd, there might be several plans to review at that point in time, and it might be a fitting board meeting to have together.
And if I may just add, this is Dag Long regarding the upcoming meetings. So I know Marcy just mentioned that there may be possibly some issues with, of course, getting physical locations for a June meeting. And I know she mentioned a location up in Carson and a location down in Vegas. The requirement pursuant to OML is you only need one location. So if you're having difficulties, you might have to deal with the Carson location or the Vegas location or whatever, but there's only one physical location that you need. And of course, you do need to, that location definitely needs to comply with safe COVID practices as well. And another thing that's kind of coming down the pike is AB 253, which we expect to pass, just not by June 1st. And that gives boards the option to continue their meetings actually virtually again, with no physical location requirement. However, there are other requirements that if you want to continue to have all your meetings virtual, and of course, the main concern is, public comments, that public comment has to be done in real time. And I know that you've been getting some possible email public comments. It doesn't say anything about email, but I'm sure that's fine as long as the only requirement is to be able to have the public comment, basically in real time. And there's also a provision that if the board likes, they can add that somebody could supply pre-recorded public comment as well.
Sophia, what was that bill number again?
253, AB 253.
Thanks.
So let's, Ann, if you're okay with it, let's take these in stages, and I'll make the motion that we suspend the May 26th meeting per Marcy's request.
This is Chris. I'll second it.
All those in favor, and let me just add as a little supportive note, I don't think we're expecting anything to actually pressing to be on the agenda in May, so I feel comfortable that we could do that without sort of much harm, and we'd be fine to meet again in June. So all those in favor of suspending the May meeting?
Aye.
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 Good. Anyone opposed? Okay, so that carries to suspend the May meeting. Then we will have our meeting that is scheduled for June 23rd. It sounds like we'll be sort of on a wait and see in terms of exactly how that'll play out. But I just wanted to clarify, Daglong, if we do have, I think Marcy said this and I understood it from you, but if we do have a single location, we could have a single location plus Zoom access as well.
What I would recommend is, yes, at least one physical location, but the board members are still able to attend either via Zoom or telephonically as you have been now. So the current open meeting law requirements for board members is just that you all can participate and hear each other in real time.
Okay. Okay. So my sense is that this relates to two things. One is that we could have a single location whenever we are able to schedule it, or two locations if that works. There would still be Zoom access for that meeting. It's just that there would also be a in-person access. And then it may, we may not have to have that location if the bill passes. And then regarding travel, for people to indicate, we have a few of our members who have been in the past and before times traveled to the meetings. And so you should indicate whether you wanted to travel, but if you couldn't travel, you could use the Zoom access for the June meeting, just because we're in a little bit of a budget crunch on travel funds. So that may influence your decision. But either way, let Cynthia know if traveling is one of your goals. Okay, so I think we're all set on that. And then maybe we should have a little discussion now, or at least sort of, if anyone has thoughts to share now, we can continue it for an in-person meeting in September, because I think the issues there are that we will have in our new budget, in the sort of FY22 budget, we'll have money to travel. It's still limited. So we need to be thinking about a location. We could pick the location where the least number of people have to travel. We could ask people, whether some of us would have reimbursed travel, and wouldn't seek it from the department. So I just wanted to get anyone's sort of suggestions today, and we could just discuss and then keep discussing it later.
So Ann, I had made the suggestion way back pre-COVID that we go to one of the rural counties, because I thought it would be easier for rural judges and attorneys and prosecutors and whoever else might want to join us to be able to do so. And I know we tentatively scheduled it up in the north part of Jones County, but Obviously, that didn't happen, but I would still make the recommendation, even though it means Drew and I might have to travel a little bit. We'll probably take it out of the county budget, not yours, Marcy. And anyhow, for the same reasons, I would make that suggestion.
And this is Chris.
Chairman,
Yeah, oh, sorry. Go ahead.
no, go ahead, Chris. I'm sorry.
No problem. I would agree with Jeff. I do think we should go out to one of the rurals, and we could even look at carpooling in some ways. There's just some other things we could do to save the department money. So I think that's all all good workarounds.
Okay.
And in honor of our departed past chairman, I think he wanted us to go to Tonopah. So, right, he did. That's
Yeah,
He did. He was born here.
I know. So I think
I think he lived here till he was in the 5th grade or something.
Yeah. So I think that would be a nice pilgrimage, and it'd be great to get together. I'm hearing from people that not only the MISPA, but the same family is doing, is it called the Joni? Is it called the
Belvada. It's the Belvada. They just had their grand opening 2 weeks ago.
So if we decide on it, they may even apparently mind, I don't know these people, but they may even be willing to give us like a room discount. Because Joni, I love you, but I'm not staying at the Clown Motel.
Hey, I live here and I wouldn't stay at the Clown Motel.
So true.
But it's fun to drive by.
Yeah, as long as you keep driving, Jeff.
All right. Okay. Well, there seems to be appetite for Tonopah. So, and it seemed, so one thing to think about is just whether you would be putting in for travel, just so that we can think that through in terms of either, reimbursing costs, reducing costs, that kind of thing, or whether you could actually say, I wouldn't need to do it. I wouldn't need to put in for travel. That would be useful to know too. So for something to think about. And our thinking was also that September, hopefully it's far enough out that we'll be a little bit more back to normal by then, but also September tends to be good weather everywhere. So
actually to that end, because I'm sure hotel space is limited.
Yeah.
Can we ask someone to as usual, Marcy or somebody there to check and see the availability of rooms and if we could get a group rate?
I can do that.
Great. Oh, thank you.
Yeah. No, I'll take care of all of that. No worries.
All righty. So that sounds good. And that would be, okay, that's September 29th. Is that a Wednesday?
Yes, it is. Would you prefer to move it to another day?
I'm just thinking whether it makes sense to move. I mean, just is Wednesday plop in the middle of the week like harder for people than of Thursday, or sort of getting there for a Thursday or Friday morning? So
I would think if you could move it to Thursday, then people could travel Wednesday after work or even Wednesday afternoon, depending on how they're getting there, and then have your meeting on Thursday and then give everybody a chance to go home on Friday that way. But
And Chair Trom, I did receive a note that the NACO annual conference is September 27th through the 29th. So we may not have to overlap.
right. Okay. So maybe the 30th actually is a good day. People on the call are going to the NACO conference. Is that would that work for them?
Yeah, Chair Trump, Dave Mendiola, that's what I was just going to bring up, was that it would really need to be Thursday. That way we can do both.
Okay. All right. So, and is it better to sort of plan on Thursday in the afternoon? So you have additional, you could get there you could get out Thursday morning.
Yeah, that would be good, because usually they wrap up Thursday morning, but you can leave early, so we can make it there. Sure.
Okay. So maybe Thursday the September 30th in the afternoon.
Hey, Dave,
Right.
Where's the NACO conference this year?
I don't think they've decided yet.
Oh, okay.
Might go back. They were going to go to Churchill, to Fallon, but I don't think they've made that final decision.
maybe the
Okay.
conference should be in Tonopah.
There you go. Perfect.
Good luck with that one.
Okay. Well, that sounds like a tentative plan. So we'll let's act on that, and then we'll hear more details. Like we'll hear back some details on that. Okay. That's great. So our next confirmation of the next meeting is going to be June 23rd at 1 p.m. Look out for notice on sort of the how and where information when that becomes available. Okay, so before we adjourn, is there anyone who would like to make a public comment? Either live or did we receive any public comments during the meeting that Cynthia, you would like to share?
I'm sorry, let me check.
Madam Chair,
Yes.
before we adjourn, I would just like to say one more time, just welcome to Tom Qualls, and we're really happy you're part of our team. Thank you.
Thank you very much. That's kind.
Yes.
Professor Crum, I checked all my inboxes and there's no public comments.
Okay, great. Thank you. So I think hearing no public comments, do I need a motion to adjourn? I always forget this. Do I need a motion to adjourn?
No, you do not.
No, you don't, but I'll make it anyhow.
I just.
Well,
watched
you
a
don't
few
even need
minutes.
a second, but I'll second anyhow.
Okay, I'm hearing. Okay, so let's adjourn. Thank you, everyone. And I will see you back in June. And just thanks again to the department for just doing great work. It's exciting to see. Yeah.
Thank you, Madam Chair. Good job.
Thank you. Thanks.
Thanks, everybody.